Another important landmark judgment relating to termination of service of permanent employees that in this series we would like to discuss. One of the landmark judgments delivered by the Apex Court in the year 1986 and that is relating to Central Inland Water Transport Corporation versus Brajo Nath Ganguly, and it was pertaining to termination of service. So the very question raised in challenging Rule Line Clause 1 of the Indian Contract Act of 1872 and the Companies Act 1956 as violative of the provisions of Article 12 and Article 14 of the Constitution of India. So, in this particular landmark judgment, that is in Central Inland Water Transport Corporation versus Brajo Nath Ganguly, the appellant, and that was Central Inland Water Transport Corporation, was a public company that was incorporated on 22nd February in the year 1967. The appellant company was a company that was owned by both the state government of West Bengal and by the government of India. A company such as the appellant in the case has been defined as under Indian Companies Act 1956 and as provided under Section 617 of the Indian Companies Act 1956. Brajo Nath Ganguly, the first respondent in the civil appeal, was at the date when the said scheme of arrangement became operative, working in the said company, and his services were taken over by the corporation, and he was selected on September 8, 1987, 67 as a deputy chief accounts officer. There was another company during that time which was known as River Stream Navigation Company Limited. It was on growing extensively. It was functioning mainly in maintenance along with looking after the flow of the river water services. Along with this, it was commanded to make full payments requisite to all its creditors on the undertaken. Association was instructed by the Honorable High Court of Calcutta to wind up though an order which was dated in the year 1967 as it was made on the month of May 5th. The first respondent of the civil appeal who was Brajo Nath Ganguly was already working with the above said company when an arranged scheme approved by the Honorable High Court of Calcutta came into effect, because of which all of his services were withdrawn by the corporation. On the 8th September 1967, Brajo Nath Ganguly, the first respondent in this landmark judgment, was appointed as the deputy accounts officer. After years have passed by, he received a letter regarding accusation made against him for showing negligence or careless attitude in maintaining the provident fund accounts. The letter he received was sent to him by the General Manager, Finance Department, and was required to be replied to within 24 hours. In his response, a detailed reply was provided by Brajo Nath Ganguly, the first respondent. However, the respondent sent by him did not create much of an impact on, as later he received a notice on 26th of February 1983 which contained signatures of the chairman, managing director of the corporation. The notice was sent to him regarding termination of his services with an immediate effect in accordance with Clause 1 of Rule 9 of the Services Rule. So, the very facts of this case that we would like to discuss now. In regarding to this landmark judgment, Central Inland Water Transport Corporation versus Brajo Nath Ganguly. The incorporation of the corporation was done by the Union government. The corporation was under complete dominance of the central government of India, and they hold all of its shares. The respondent in this case used to work for a company which later came to liquefy as per the orders of the court, and thus was given an authority in the appellant's corporation under the requisite terms and conditions. So Mr. Brajo Nath Ganguly joined as Deputy Chief Accountant Officer in the corporation and later on became the Deputy Financial Advisor and Chief Accounts Officer. Through his determination and hard work, so a suit was initiated by the respondent at High Court of Calcutta, stating that Rule 9, Clause 1 was arbitrary and unprincipled, because of which the decision of the Honorable Board was in respondent's factor. So, this led the plaintiff to file a suit in the apex court, and that is the Supreme Court of India, for the grants of special leave. However, here also the decision of the court was against the petitioner, and the grant for special leave was cancelled by the Supreme Court, as the court held that Rule 9 Clause 1 to be void under the Indian Contract Act 1872 as per the provisions of Section 23. So the very legal issues and provisions raised in this landmark judgment were relating to. Did Article 12 of the Indian Constitution hold its jurisdiction over the corporation that comes under the definition of state? Further, whether Rule 9 Clause 1 was immoral, as under Section 23 of the Indian Contract Act 1872. Further, the question raised regarding can power involved by the Rule 9 Clause 1 be declared void in violation of the constitutional provisions relating to Article 14 of the Constitution. So the apex court laid down the ratio decidendi, where it was held that the Central Inland Water Transport Corporation Limited was not just a regular company as defined under Section 617 of the then Companies Act 1956, but fully owned by three governments at the same time, namely the central government or the government of India, the government of Assam, and the government of West Bengal jointly. The bargain put forward was based on unethical terms as it contradicted the justified reasons and seems to have taken place under unfair age over the others. And the state under Section 39 should favor the policy of safeguarding its citizens and providing equal pay for equal work for both sexes. As for example, males and females equally, decreasing the concentration of wealth and means of production to the common detriment. Rule 9 Clause 1 of the Central Inland Water Transport Corporation Limited. Further, the apex court, as to service, discipline, and appeal rules of 1979 granted upon the corporation the power to end the service of a permanent employee by giving him 3 months' notice in writing or to pay them the same 3 months' basic salary or pay and dearness allowance. And further, the apex court held that a clause such as Rule 9 Clause 1 in a contract of employment interfere with the large sections of the public and was unfavorable to the basic public interest and might lead to generating a lack of confidence in the heads of those who encounter it, and it was against the public welfare. So, in this particular landmark judgment, as regarding the very relevance of the terms the state which were used in the Constitution of India, both in Part 3 and Part 4 of the Constitution, does not merely conclude it as Union of India, but also includes all organizations that are dominated and controlled by the government. Therewith, three conditions which the court regarded as the key ingredients which showed that the corporation was a body of the government itself under the public sector, as it was defined in the Constitution of India as per the provisions of under Article 12 of the Constitution. So the very three conditions that were referred, the corporation was completely funded by three governments jointly and managed by chairmen and directors that were appointed by the central government and was under control and authorization of the central government. So, in that connection, in this landmark judgment relating to termination of service of a permanent employee, as per the Rule 9, Clause 1 of the Indian Contract Act 1872 and of the Companies Act 1956, the then and in violation of Article 12 and Article 14 of the Constitution of India. Now we would like to conclude our landmark discussion on this important landmark judgment, and that is Central Inland Water Transport Corporation Limited versus Brajo Nath Ganguly in the year 1986. As since the term immoral means unreasonable or unprincipled, it is right to say that an immoral bargain was an unprincipled bargain that would be antithetical to what is just and justice. Therefore, if an agreement or a contract is immoral or unconscionable at the time of its formation or creation, then the court may diminish the enforcement of such a contract or agreement. So, accordingly, Rule 9, Clause 1 brought in the notice before the apex court in this matter was in opposition or contrast to the government policies and claimed to be void according to the very provisions as underlined under Section 23 of the Indian Contract Act 1872, as it provides arbitrary powers upon the corporation. Besides that, it did not signify that who is to perform and use these powers on the behalf of the corporation, as well as there are no specific rules and regulations which illustrates that in what sort of situations or circumstances the corporation may exercise the powers referred to in Section 9, Clause 2. So, this was the landmark judgment delivered by the apex court. In this landmark judgment, that is Central Inland Water Transport Corporation Limited versus Brajo Nath Ganguly, relating to the very question of termination of service of permanent employees, and with reference to Rule 9, Clause 1 of the Act. Also, it made reference to the Indian Contract Act 1872, then the then Companies Act 1956 and how they violated the provisions laid down under Articles 12 and 14 of the Constitution, in particularly defining under Article 12 what is state and which instrumentalities they fall under the very definition of state, and regarding Article 14, right to equality and equal protection of law, the very question raised regarding the question of arbitrariness of those corporations which are constituted and formed and established by either the government of India or the Union of India or by any state. So, in this particular landmark judgment, Central Inland Water Transport Corporation Limited versus Brajo Nath Ganguly, the apex court, dismissed the very appeal made by the Central Inland Water Transport Corporation Limited and held the appeal of Brajo Nath Ganguly as it was a complete arbitrariness made by the Central Inland Water Transport Corporation Limited by framing the Rule 9 Clause 1 with reference to the provisions of Indian Contract Act 1872 and with reference to the then Companies Act 1956 and how the very rule violated the provisions laid down under Article 14 of the Constitution and how the Central Inland Water Transport Corporation Limited is falling under the very definition of state as provided under Article 12 of the Constitution of India as one of its instrumentalities.